Good afternoon. My name is Mihaela Verga, and I'm a lecturer at the University Bacovia from Bacau. The exposure that I prepared refers to the infringement procedure against Romania. We first analyzed the existing legal framework on the matter. Then we present the implementation of this procedure in the member states of the European Union. But last but not least, the article refers to a series of aspects regarding the areas in which this procedure was directed against Romania and the measures taken by the Romanian government to solve the existing problems. The infringement is a procedure initiated as a result of a breach of primary and secondary legislation adopted at the European Union level. Its purpose is to harmonize the legislation of each member state with the system of the European Union law, giving member states the opportunity to solve a particular issue determined by the European Commission before it refers the Court of Justice. The legal basis on this procedure can be found in some articles in the Treaty on the Functioning of the European Union, and it highlights a number of specific steps that are required to be followed. In our presentation, we distinguish between the informal phase and the formal phase. The first one concerns the conduct of the discussions and the search for amicable solutions by the European Commission and the Member State to avoid the initiation of this procedure. The Commission thus identifies the infringement cases which may relate to infringement of the European Union law, which are either non-transposition of a directive within the express term, improper transposition of a directive, or incorrect application of the European Union law, failure to notify the national measures taken and applied. The procedure begins as a result of the Commission's own investigation or complaints from citizens, businesses, or other stakeholders, as well as a result of the failure to communicate the transposition of a directive by a member state. For better processing complaints of citizens, the Commission will make available a standard form of such application that is completed online according to the requirements indicated. Then there are two different moments: recording and analyzing the case of infringement. After a careful examination of all existing facts, the Commission will either close the case or send a letter of notification. The formal phase has two distinct important stages: the pre-litigation stage and the contention stage. The first one begins when a letter of formal notice is sent to the member state concerning the infringement found. The purpose of this document is to give the member state concerned the opportunity to present its views on the issue identified. The member state's observations are the response to this letter, which must be provided within 2 months. This is followed by a reasoned opinion issued by the Commission within 3 months of receipt of the member state's explanation or its lack of reaction. That opinion is a detailed statement showing the reasons that led the Commission to find violation of the legal system of the European Union. It is followed by the member state's reply, which must be sent within 2 months of receipt of the Commission formal position, and it presents detailed measures that will be taken by the state. The above period may be extended by the Commission due to special circumstances. The contention stage begins with the referral to the Court of Justice by the Commission. Next, the settlement in fact of the case follows. Thus, the European Court determines whether there is a violation of the European Union law in the dispute submitted. If so, it orders the administration of proofs and conducts the trial. However, the Court of Luxembourg is not competent to state the measures to be taken in the state concerned. An important moment in this phase is the implementation of the judgment of the court. Thus, the member state concerned has 3 months to take the necessary measures and to forward them to the Commission. If the state does not comply, the Commission shall send the member state a second letter of formal notice, starting its obligation to take the appropriate measures. In the absence of the latter, after the expire of 3 months, the European Executive shall issue a reasoned opinion and indicates the points at which the state has not complied with the judgment. If the member state does not take adequate action in this case either, the Commission will bring it before the court for the second time. The Commission may request the court to order the state concerned to pay a lump sum and penalty payment. The 2 sanctions referred to above were combined for the same infringement of the European Union law in the first case in the field, by the judgment of the Court of Justice, Commission against France, pronounced in 2005. For reasons of transparency, the Commission publishes the criteria it intends to apply to the court to indicate the appropriate financial penalties in the circumstances of each case and the method of their calculation. These criteria refer to the seriousness of the infringement, the period of the violation, the state's ability to pay, ensuring that the deterrent effect of the section can avoid recidivism. In 2020, the new procedures were launched for all member states, and more than 50% of member states have increased their procedures of infringement, and only 7 member states have managed to reduce them. This indicates a serious problem with their attitude towards the respect for the European Union law. In 2021, the Commission initiated another new cases for the European Union member states, most of which covered countries such as Spain, Greece, Poland, Bulgaria, Italy, Germany, and Romania. The only country that obviously stands out in terms of the small number of open infringement cases is Denmark, followed by Lithuania and Estonia. The infringement procedure in Romania. Over than 90% of the infringement cases initiated for Romania in the period 2009-2014 were in the field of environment. In 2021, 80 procedures were launched for Romania, most of which were registered in the fields of environment, energy, financial stability, financial services and capital markets union, mobility and transport, home affairs. It is significant that most cases, 53, are in the first stage of the procedure. In another 21 cases, the Commission issued a reasoned opinion. In a case on environment initiated in 2009, the judgment for Romania has begun in 2018, and after 2 years, it was sentenced to pay the cost by judgment of the court. It should also be noted that in over 50% of the cases mentioned above, the Romanian state did not send the Commission its point of view, which illustrates its tendency not to communicate in an effective and efficient way with the European Executive, even from the beginning of this procedure, in order to remove any existing irregularities. Also, the large number of cases launched in 2021 highlights the delays registered by Romania regarding the obligation to comply with union law. We further analyzed some interested aspects regarding a case of infringement directed against Romania, finalizing with the pronouncement of a decision of the Court of Justice. In this regard, the court ordered Romania to pay the Commission a lump sum of 3 million euros. Some conclusions. The Commission's supervisory work on compliance of the national legal systems with the European Union law is proving to be effective because the most infringement cases are launched at its own initiative. For the best execution of the European Union law, the Commission have established various modalities such as guidance documents, imposition of plans, expert groups, providing trainings. The most important observation that can be made by analyzing the data provided in the Commission's annual reports is that the objective of the infringement procedure, which is to persuade member states to comply with the European Union law, has been achieved by reducing the number of cases substantially in pre-litigation stage. Of the cases pending, over 66% are in the first moment of the pre-litigation phase, 20% in its second stage, which highlights the tendency of Romania not to be constantly concerned about the compliance of the national legal system with the European Union law. However, in 2020, the positive changes of perspective of the Ministry of Foreign Affairs were made in this regard. The latter has been elaborated the annual transposition plan 2021, approved then by a memorandum in a meeting of the government of Romania. This document contains useful and detailed information on the transposition of the directives, with special attention to the urgent transposition of the remaining 17 directives for which the infringement procedure has been initiated. Thank you.